It is so good to be here again, and I would like to thank organizers for organizing this event. Well, and before I start, I have just one question. Is it some special tune, or is it just, a ring of a bell?
Maybe it will be like a horror.
Okay, so...
Maybe a moment that we are going to present it.
Yes.
If I get a heart attack, then you are responsible then.
Is it slightly...
Nice. Thank you. Well, as you can see, I will address an issue of subsidiary agreements in EU law. Does it work? Yes. Well, and the question is, what are subsidiary agreements? And why are they subsidiary? And to what are they subsidiary? Well, and the Treaty of Rome provided in Article 220, which later became Article 293 of the EC Treaty, that member states may conclude international treaties among themselves in certain well-defined areas. And the aim was to promote the achievement of those objectives which were related to the EU activities, but which the EU could not regulate by its own law, as it did not have the competence to do so. And you can see the text of that provision on the, left side of my slide, the purple one. And by the way, there was a similar provision later adopted by the Maastricht Treaty. You can see it on the right side, in the white color. And this provision was pursuing the similar objective in the area of the third pillar of the Treaty of European Union, in the area of the internal security and justice. And these two provisions, they were repealed. They don't exist anymore. And that's something which is related to the sovereignty of states, the topic which my colleague Professor Šmíková addressed just a while ago. This provision was repealed, but that doesn't mean that member states of the European Union, that they cannot conclude this type of agreements anymore. And this is why I'm addressing this issue in my chapter and as well here in my contribution. Well, and both these two provisions envisaged that the EU objectives could be achieved either directly by the European Union within its competencies and by the European Union law, or that another type of cooperation among member states as equals is possible outside the European Union, but in close connection with it and with its objectives. And what is important, this type of cooperation was achieved through the regular international law, through regular international treaties closely linked to what the EU does. Well, another question is, what was the purpose of these provisions and why were they adopted? Well, and these two provisions, they represented an acknowledgement of the reality. There are certain areas in which cooperation is necessary, meaningful, but at the same time these areas are perceived for some reason as sensitive, as is, for example, the area of justice, of criminal matters, healthcare, and so on. And it is this sensitivity that has resulted in a certain reluctance on some member states to further limit their sovereignty and to transfer additional powers to the European Union. And subsidiary agreements were a solution to this problem. They were a solution to this contradiction. They allowed cooperation without significantly limiting the sovereignty of member states and without affecting their equality, and that's important. And they can be described as subsidiary because that was their nature vis-à-vis the EU law. And this was confirmed by the case Ibezering. You can see it on my slide, where the Court of Justice said that member states could only regulate under these treaties only those matters which could not be regulated directly by the European Union law. So they were subsidiary in their nature, or perhaps I can say complementary to what the European Union does. And these treaties were closely linked to the European Union. The institutions of the European Union, the Court of Justice, were involved in the interpretation. The EU institutions were involved in the drafting. You can find these treaties also in official journal of this European Union. And the interpretation by the Court of Justice was possible by the article, or under the Article 273 of the TFEU, which is a provision which allows member states to refer a dispute between themselves to the Court of Justice for resolution, and then includes also the task to secure the uniform interpretation. So, and the advantage from perspective of member states and their sovereignty was that these treaties were not a part of the EU law. I already said that they were part of international law. Thus, the principle of supremacy did not apply in the case. And by the way, I was trying to search for some information on how it works within the United States. And in the United States, that we have something similar, or they have something similar. They call it interstate compacts, and those are also agreements or treaties that can be negotiated among states of US Federation. There are some similarities with subsidiary agreements, but also some important differences, but I will not address them here, but in my chapter. Well, but at this point, I would like to simplify it and conclude that these treaties are an acknowledgement that despite membership in the European Union, member states remain sovereign states and can therefore regulate their affairs not only by their own national law, but also by international law, which do not fall directly within the competence of the European Union. Well, and at this point, we need to ask another question. It's going to be about questions. Why do we need something like subsidiary agreements in the first place? And I have already outlined certain reasons for their introduction in the past. It was the will to cooperate, but the reluctance to further limit sovereignty and to further delegate additional powers to the EU. But why could, and perhaps why should, these treaties be used also in the present? Well, and I'm asking questions, so I should answer them. And in order to answer them, I need to identify the shortcomings and weaknesses of the current states of European integration. And I will try to take it step by step and be brief, but this is really a hard task. Firstly, I'm convinced that the European Union has a serious problem with principles of proportionality and subsidiarity. There are many studies pointing out that they are applied by the EU only formally. And this is manifested in the EU's attempt to regulate comprehensively what were originally only peripheral areas of European cooperation. And this empties somehow space for member states and their law. And the EU is placing limits on member states even where it has no real powers to do so. I think that our friends from Poland would be able to provide several lectures on that topic. And thereby the European Union is able to influence the internal policies of states without having a direct competence. It sometimes seems as the EU law has no boundaries. And this phenomenon is further strengthened by the legislative instruments the EU can use. And I'm addressing here directives. Directives allow the European Union to enter the areas of national law which would be forbidden to federations in federative states due to the lack of competencies. Another significant problem of the European Union at the moment is its over-constitutionalization of its law. The Union constitutions, and we all know that under European Union constitution we understand the primary law, the founding treaties. Well, it contains both regulation that traditionally belongs to domestic constitutions, and in addition to that, a range of economic and other policies. And this constitution is then broadly interpreted by the Court of Justice. Its decisions are becoming also part of this so-called constitution. And within the framework of interpretation, these constitutional rules, which are rather general, they are often supplemented by specific regulation of statutory law through the interpretation of the Court of Justice, which means that the Court of Justice elevates certain pieces of regulations and directives on the constitutional level. And this mess of law is extremely difficult to change. We all know that changes to primary law have to be approved by member states, but that's not it. It's a very complicated procedure which involves also the EU institutions. And, well, that's absolutely fine, but this is how it can work with real constitutional rules, where a certain degree of stability is a priority. Conversely, it's, at least according to my opinion, absolutely inappropriate in case of a regulation that is a part of this constitution essentially by a chance, by accident. In its case, on the other hand, is reasonable to require a certain degree of flexibility, which we don't have in the European Union. Well, and another problem is quite opposite to over-constitutionalization. That is that member states simply leave too much room for the Commission to promote its own policy or ideology, if you want, and its implementation through regulatory acts that are in fact on a sub-statute level in their nature. And in this way, regulations binding on businesses in the internal market are adopted on a large scale, and this is done in a way that does not guarantee any real democratic control. So the democratic legitimacy is therefore quite low. So we therefore have on one hand an oversized constitution, and on the other hand oversized implementing acts, whereas the middle level, the statutory legislation, is somehow neglected. And even the secondary law has a number of flaws of legislative technical nature. That's an important thing. The legislation is quite often fragmented into many acts, and it is also, and I'm sorry for this word, but it's quite often talkative. And if you need some empirical proof, just take any regulation or directive adopted in the 80s and compare it with regulations or directives which are being adopted nowadays. So the problem is that it is extremely difficult for addressees of such legislation to understand it. And it is also evident that there is a little willingness on the part of EU law to address these problems in a truly systemic way. There were some efforts in the past, for example, concerning the consumer protection law and its reform, but the real success is disputable in their case. Well, and in addition to that, the very setup of the European Union itself, and I think that here we can blame the European Commission, might be a sort of a problem, since it often solves problems with ordoliberal approach, and in practice this is manifested by the emphasis on regulating as early as possible and as widely as possible. So, and we all know it under the saying, the US innovates, the European Union regulates. So, on the EU side, there is prevailing belief that it has to regulate problems that even loosely relate to functioning of the internal market. And it is also expected that not only member states, but also third countries will comply. Digital Markets Act as an example. Nevertheless, this means that we have created within the European Union a space in which there is excessive regulation, which is really difficult to change, and which is quite often incomprehensible to its addressees. And the consequence is that the economic growth is quite often undermined, and the scope for creativity and innovation within the European Union is reduced or threatened. And what is quite interesting is that the European Union repeatedly sets these great goals, Lisbon strategy, for example, but these goals are not met. I mean, who today remember the Lisbon strategy and how it ended? And unfortunately, no one was held ever accountable. And we have new great targets that has to be achieved. And I couldn't resist to, when I saw this picture, I thought that this must be the part of this presentation. Unfortunately, I would say that, it's too true to be really to be really funny, but it somehow explains what I meant by this small criticism. Well, it is also quite clear that any solution from within the European Union is simply not possible. It seems to me that the European Union is clearly incapable of any other approach. Things are only getting worse. And the question is, therefore, what to do about it and how to respond to the problems which I have described. And I believe that here the intergovernmental method of integration, but closely linked to the European Union, implemented through subsidiary agreements may be such a good solution and alternative. And Professor Sehnálek was mentioning sun in his presentation, and here I think that I will use this as my example in my presentation, since what I'm trying to propose is to think about the European Union as about a solar system. The EU as a huge sun in the center where the core of integration is secured, and that's absolutely fine, and the planets orbiting around, representing the subsidiary treaties where the cooperation is secured based on equality and based on cooperation, voluntary cooperation of member states. Well, and we have good examples of subsidiary agreements that have been used in the past. You can see some of them on my slide. For example, the Brussels Convention, which was adopted on the basis of the Article 293 of the EC Treaty. It was a true subsidiary agreement. Subsequently, the Rome Convention, which, although not directly based on this provision, was a consequence. It was a certain spillover of the Brussels Convention in the area of justice, cooperation in civil matters. And both these treaties, they were negotiated by consensus of member states and are a result of compromise among them. Both have been widely interpreted by the Court of Justice, and both have over time become a model for EU regulations once it acquired competencies. So once cooperation based on mutual agreement between member states as equal had proven itself, it was easy to confer new competence on the EU, and the EU simply incorporated the result of the former agreement of member states into EU legislation. So from this perspective, these two treaties can be considered as an extremely successful achievement of member states or by member states, and a possible model also for other types of cooperation in other areas. So it was a two-step integration, first among member states, and then the second step was the EU and its legislation and expanding to further areas of justice in civil matters. Another example is Convention of the Protection of the European Community's Financial Interest, and this one was based on the K3 article and had similar fate, and this treaty also proved its worth by eventually becoming part of EU law as a result of the transfer of powers which was affected by the Treaty of Lisbon. Similar cooperation was used also by the Fiscal Compact. In the case of this treaty, however, the primary reason was rather the desire of the majority of member states to bypass the minority and come to a quick conclusion without the necessity to change the primary law. The minority was represented by the Czech Republic and by United Kingdom, by the way. We oppose these treaties. This is how it sounds. And this treaty is an example of rather problematic use of this type of treaties, but essentially harmless, since those states who did not agree, well, they were not involved, and they simply were not affected by these new introduced mechanisms. So no problem really happened. There were some other areas where it was envisaged that the treaties will be adopted, but for some reasons this didn't happen, and I'm not going to deal with it now. I've done something with it doesn't work. So if I may ask you to.
The same.
It's still the same. Well, never mind. I think that these treaties have just one major problem. national governments, and I'm using this on purpose, I'm referring to national governments, not member states. National governments have little incentive to use them. It is easier for national politicians to deal with issues of common interest through the EU institutions rather than solve the problem by themselves. So, as you can see, I don't blame the... Excellent, thank you. I don't blame the EU itself, I blame the national governments primarily. And, well, subsidiary agreements, since they are typical intergovernmental treaty, they require careful negotiation of the content. They require ratification through national parliaments. According to national constitutional rules, this also involves the attention by popular and by media, and this is also a certain type of control. And a careful deliberative procedure must take place in every member state, and this all affects the content of these treaties. And also, the advantage is also greater democratic legitimacy, since they are approved by all parliaments in member states, and we can respect the priorities and needs of all member states. Well, and again, if this solution proves to be successful, it may become a model in future for the EU legislation, as it happened with Brussels and Rome Conventions. And the advantage of these treaties is also that they can take advantage of the existing institutional structure of the European Union when it comes to the interpretation and enforcement. So what I'm proposing, therefore, is that the EU should continue to focus primarily on the core of integration, and that the periphery, as is, for example, the climate change, the Green Deal, these topics are important but rather controversial. They should be, or health cooperation, they should be left rather to member states, and they can be dealt by this type of treaties. Since it seems to me that these issues are simply too important to be left just to EU officials without the involvement of the true democratic element in member states of the European Union. And as we can see from the content of the existing treaties, the advantage is that they won't suffer from the legislative technical disadvantages which we have seen on the examples of EU law. Well, and in terms of integration theory, these treaties represent a certain step backwards, a return to intergovernmental method and return to equality of states, but I believe that sometimes a step backwards makes it possible to take 2 steps forward in the future. So these treaties might be a fair solution from the perspective of all member states, but of course that would also require to rethink how the competencies of the European Union are designed in the founding treaties and how they are interpreted by the Court of Justice, and the question is whether we have the will. But I think that we should. Which brings us to the policy making. We are not policy makers, so I will stop here, and you will find out more in my chapter, and perhaps I will deal more with these treaties and the content on the next conference. Thank you.